Hello everyone, welcome back to Learning Legal English through Case Laws series. In this video, we'll study Case Laws number 45/2022/AL about determining murder crime, in the case of incomplete commission of crime. Case Laws number 45/2022/AL about determining murder crime, in the case of incomplete commission of crime. Includes 5 parts. Part 1, Source of the Case Law. Part 2, Overview of the Case Law. Part 3, Content of the Case. Part 4, Assessment of the Court. Part 5, Rules. This case law is approved by the Council of Judges of the Supreme People's Court on November 25, 2021, and announced in Decision Number 594/QDCA dated December 31, 2021 of the Chief Justice of the Supreme People's Court. Criminal Appellate Judgment Number 10/2021/KDTMGDT dated September 24, 2021 of the High-Level People's Court in Hanoi regarding criminal case of murder against the accused Nguyen Ba Thi, Pham Hong T1, Pham Quang V, Nguyen Din and K. Part 2, Overview of the Case Law. Case law situation: the accused deliberately conducted the action with the intention to deprive the victim's life. The victim's health is affected with infirmary rate of 100%. Legal resolution: in this case, court must determine the fatal result has not occurred. The accused must bear criminal responsibility for the crime of murder in the case of incomplete commission of crime. Key words of the case law: deprivation of life. The health damage rate is 100%. Incomplete crime. Killing. Part 3, Content of the Case. Nguyen Ba Thi and Pham Quang V, Pham Hong T1 and Nguyen Din and K are social friends. At the beginning of 2018, Nguyen Ba Thi had a romantic relationship with Ms. Lu Min A1, born in 2002, residing in Group 41, O Ward, D District, Hanoi. By the end of 2018, the two broke up. Through research, Nguyen Ba Thi knew that Lu Min A1 fell in love with Mr. Hong Quoc A, born in 2002, residing at House 9A, Alley 344, Alley 50/1, Street N, Ward T, District L, Hanoi, who was an old friend in Nguyen Ba Thi's group, so he was angry and wanted to find and beat Mr. Hong Quoc A to take revenge. Around 23:30 on January 5, 2019, after drinking alcohol, Nguyen Ba Thi called Nguyen Din and K to ask about Mr. Hong Quoc A falling in love with T's lover, and at the same time, asked him to go to the market area M in Ward B, District H, Hanoi to talk. At this time, Nguyen Din and K was hanging out with Nguyen Hue Nam S, born in 2000, Vu and K1 and another one named K2, whose identity is unknown, on 03 motorbikes in the area near Bridge C. K received Nguyen Ba Thi's call, so he invited S, K1 and K2 to go to the M market area to meet Nguyen Ba Thi. After Nguyen Ba Thi called Nguyen Din and K, he met Pham Quang V in the area of Street C, so he asked V to go with him on business. V and T rode motorbikes to the roof of Tunnel L, District D, Hanoi, and met Pham Hong T1 and Phan Tuan A2, born in 2000, and subjects DD, D, and 02 other young people, whose identity is unknown. When DD asked T where he was going, T said to find this dog, meaning to find Hong Quoc A, and asked DD again, "Are you going with me?" DD and TL, Tuan A2, D and the other 2 young people all agreed to go along. After that, Nguyen Ba Thi, Pham Quang V, Pham Hong T, Tuan A2, DD, D and 02 young people of unknown origin moved by motorbikes from the roof of L to the M market area. Here, group of Nguyen Ba Thi meets K, S, K1 and K2. In the group, only Nguyen Din and K knew Hong Quoc A's house, so Nguyen Ba Thi asked K to lead the way. K asked, "What's wrong?" T replied, "He plays with me but he bites me, eats my ex-lover, you lead me to destroy him." Nguyen Ba Thi threatened that if K did not show the way, he would consider K an enemy. Because of this, Nguyen Din and K agreed to lead the way for T and the group to go to Mr. Hong Quoc A's house in District L. Before leaving, Nguyen Ba Thi told everyone to fill up at the petrol station on V Street, District H, T will pay. At the same time he told V to go get the weapons, but K and V stopped it. After that, Nguyen Ba T and K, V, T1, Tuan I2, K1, S, K2, DD, D and 02 young people of unknown identity rode on 05 motorbikes, of which Tuan A2 and T1 rode one a Green Wave brand motorbike with control plate of 29C1-613.93, K and subject named K2 rode a Black Wave brand motorbike with control plate 29B1-936.67, and went to Ward T, District L. When Nguyen Din and K brought the subjects to Hong Kwake's house, Nguyen Ba T called, but Mr. Hong Kwake did not come down. T threatened, "Do you believe that 5,000 dong of gasoline will burn your whole house?" So Mr. Hong Kwake was afraid and went down to meet T and talk, while the other subjects went out to the alley to wait. While talking, Nguyen Ba T said, "Do you know she's my lover? How many times have you kissed her? Have you done anything?" But Hong Kwake didn't admit it, so T shouted, "Fuck out." At this time, Pham Quang V went in and called Mr. Hong Kwake out to talk. When Mr. Kwake went to the entrance of the alley, to the position where T1 was standing, Pham Hong T1 said, "This guy looks so handsome for a lover stealer." Hearing that, Mr. Hong Kwake nudged Pham Hong T1's shoulder, then T1 kicked him twice in his leg. When Mr. Hong Kwake reached the end of the alley where the group was parked, Pham Quang V told Mr. Hong Kwake to sit down. Pham Hong T1 came and kicked Hong Kwake's knee with his right foot, then ran to get a stick and brick to hit, but was interrupted by Tuan A2, so T1 threw the brick and stick away. At this time, Nguyen Ba T said, "DD hit him," then DD rushed in and kicked Hong Kwake with his foot, causing the victim to fall on his side. Pham Quang V rushed in and pulled Hong Kwake up and said, "Do you know what is prison hit?" Then Mr. Kwake pushed V's hands out. V used his knee to hit 01 time in the hip area of Mr. Kwake. Mr. Hong Kwake backed up from the original position about 01 then DD rushed in and kicked him in the face 01 time, causing Mr. Kwake to fall on the street, lying with head holding position. DD continued to use his foot to stomp 03-04 times on Mr. Hong Kwake's head area. Seeing that, Pham Hong T1 rushed in and kicked 01 time with his foot on the back area of Mr. Hong Kwake. At the same time, Nguyen Ba T walked out from the alley and said to Pham Quang V, "There's a wooden piece," at the same time, showed V a piece of wood with an area of about 40 by 60 centimeters nearby. V picked up the piece of wood, swung up and hit on the head of Hong Kwake, splitting the wood in half. At this time, Nguyen Din and K2 witnessed T's group finished beating Hong Kwake and got on the motorbikes to go home. DD continued to pick up broken pieces of wood to hit Mr. Hong Kwake when the victim was still lying on the road. Pham Hong T1 rushed to use his foot to stomp on Hong Kwake's face. Nguyen Ba T said, "You're killing him?" After that, Pham Quang V took on the motorbike to return to the position where Kwake was lying and said, "You lie still. Tomorrow I don't see you lying there, I will beat you again." Nguyen Ba T also said, "Are you dead yet?" But Hong Kwake just moved and couldn't say anything. After that, all the subjects got on motorbikes to go home. Mr. Hong Kwake was taken to the emergency room at V Hospital by the people nearby. On January 8, 2019 and January 10, 2019, the Investigation Police Agency of District L proceeded to emergency arresting Nguyen Din and K, Pham Hong T1 and Pham Quang V. After the incident, Hong Nguyen Ba T fled until July 14, 2019 before surrender. The case was then transferred to the Investigative Police Department of the Hanoi City Police for settlement according to its competence. The conclusion of forensic examination of injuries number 68/TTPY dated January 16, 2019 of the Forensic Center, Department of Health H, for victim Hong Kwake determined, victim Hong Kwake the main bone of the nose was broken, the collection of fluid from the maxillary sinuses and the sphenoid sinuses on both sides, left hemisphere subdural hematoma, subarachnoid space hematoma, cerebral edema erased the boundaries of the brain coils in both hemispheres, midline right inclined. The brain system is out of balance. Hematoma under the scalp of the right top. Swelling of the left temporal forehead, bruising and swelling of the forearms on both sides, swollen shoulder, back of left hand. Conclusion: Mr. Hong Kwake suffered a traumatic brain injury and is currently living in a vegetative state. Currently, the extent of sequelae caused by traumatic brain injury has not been evaluated. Additional assessment is recommended upon discharge from the hospital. Most likely injuries caused by dull objects. The health damage rate is 100%. Civil liability. During the investigation of the case, Ms. Pham Ton T2, the legal representative of the victim Hong Kwok, confirmed that the representative of the families of the accused Pham Hong T1, Pham Quang V and Nguyen Din and K compensated her family with a total amount of 75 million VND. Ms. T2 continued to ask the defendants to compensate Hong Kwok A when the case was brought to trial. The first instance criminal judgment number 150/2020/HSST dated May 18, 2020 of the Hanoi People's Court decided, declared the accused, Bong Nguyen Ba T, Pham Quang V, Pham Hong T1 and Nguyen Din and K guilty of murder. Nguyen Bat, applying point N, Clause 1, Article 123, point S, Clause 1, Article 51, points H, Clause 1, Article 52, Article 39, Article 48, Article 58 of the Penal Code, accused Nguyen Bat T in prison for life. The prison term is calculated from July 14, 2019, regarding civil liability, forcing the accused to compensate Mr. Hong Kwok A represented by Ms. Pham Ton T2 the amount 400 million VND. Pham Quang V, applying point N, Clause 1, Article 123, point S, Clause 1, Clause 2, Article 51, Article 38, Article 48, Article 58 of the Penal Code, accused Pham Quang V 20 years in prison. The prison term is from January 10, 2019, regarding civil liability, forcing the accused to compensate Mr. Hong Kwok A represented by Ms. Pham Ton T2 the amount 300 million VND, compensated 5 million VND, still has to pay 295 million VND. Pham Hong T1. Applying point N Clause 1 Article 123, point S Clause 1, Clause 2 Article 51, Article 38, Article 48, Article 58, Article 91, Article 101 of the Penal Code, accused Pham Hong Ti 12 years in prison. The prison term is from January 8, 2019, regarding civil liability, forcing the accused to compensate Mr. Hong Kwok A represented by Ms. Pham Ton T2 the amount 250 million VND, compensated 65 million VND, still has to pay 185 million VND. Nguyen Din and K. Applying point N Clause 1 Article 123, point S Clause 1, Clause 2 Article 51, Article 38, Article 48, Article 58 of the Penal Code, accused Nguyen Din and K 11 years in prison. The prison term is from January 8, 2019, regarding civil liability, forcing the accused to compensate Mr. Hong Kwok A represented by Ms. Pham Ton T2 the amount 154,069,000 VND, compensated 5 million VND, still has to pay 149,069,000 VND. In addition, the first instance court also decided on late payment interest, evidence handling, court fees and informed the right to appeal according to the provisions of law. Nguyen Bat. On May 26, 2020, accused Nguyen Bat filed an appeal to reduce the penalty. Nguyen Din and K. On May 25, 2020, accused Nguyen Din and K filed an appeal to reduce the penalty. Pham Quang V. On May 28, 2020, accused Pham Quang V filed an appeal to reduce the penalty. Ms. Pham Ton T2. On May 29, 2020, the legal representative of the victim, Ms. Pham Ton T2, filed an appeal requesting an increase in the punishment for the defendants and said that the application of Clause 2, Article 123 of the Criminal Code with accused Nguyen Din and K was not suitable. The amount of money smeared is insignificant compared to the loss spent to cure Mr. Hong Kwok, requesting for reconsideration of the sentence. In the protest decision number 05/KNVTVKS dated May 26, 2020, the chief procurator of the Hanoi People's Procuracy protested against the first instance judgment, in the direction of increasing the penalty against accused Pham Quang V, applying Clause 2, Article 123 of the Penal Code, to reduce the penalty for accused Nguyen Din and K. At the appellate court hearing, the accused still appealed to reduce the punishment. The legal representative of the victim Hong Kwok A withdraws the entire appeal, proposed to reduce the punishment for accused Pham Quang V, Nguyen Din and K and Pham Hong T1. The representative of the high-level People's Procuracy in Hanoi withdrew all protests, proposed to keep the punishment for accused Nguyen Ba Thi, reduced the punishment for accused Pham Quang V, Nguyen Din and K and Pham Hong T. Each accused was about 6 to 12 months in prison because in the appellate court the accused have new extenuating circumstance which is compensation for damage. The defending lawyer for accused Nguyen Ba Thi and the accused both presented difficult circumstances. The accused did not know his father's face since childhood, his mother was a laborer with low income, the accused was illiterate and had no job. After committing the crime, the accused was very regretful, looking forward to considering reducing the punishment. Lawyer and accused Pham Hong T1 proposed to consider reducing the accused penalty because when he committed the crime, accused T1 was only 15 years and 4 months old, his family situation was difficult, his mother died early, his grandfather was awarded the Resistance Medal. After the trial, he influenced family to compensate an additional amount of 35 million VND. Lawyer and accused Pham Quang V both presented the accused family with difficult circumstances. The accused influenced the grandmother to additionally compensate the victim an amount of 300 million VND and presented the martyr's fatherland of Nguyen Van A, who is the accused uncle, so he proposed to reduce the defendant's punishment. Accused Nguyen Din and K apologized to the victim's family for the crime, and at the same time influenced the family to perform the obligation to execute the judgment, compensate the victim with an amount of 150 million VND, requesting a reduction in the punishment. The accused Nguyen Din and K's lawyer said that the prosecution of the accused in Clause 1 of Article 123 of the Penal Code is inappropriate, but it is necessary to apply case law number 17 to judge the accused in Clause 2 of the article. An adverse withdrawal of an protest against the accused is not in accordance with Article 336 of the Criminal Procedure Code. The accused has fulfilled the civil compensation obligation, so he proposes to reduce the accused compensation. The representative of the Procuracy argued and maintained the above point of view. The legal representative for the victim confirmed that the families of the accused Pham Quang V and Nguyen Din and K had fulfilled their civil compensation liability according to the first instance judgment. Accused Pham Hong T1 compensated an additional VND 35 million. At the appellate court hearing, all the accused apologized to the victim, repented of their crimes and were in difficult circumstances, so they withdrew their appeal request and proposed to reduce the penalty for the defendants. Quang V, Nguyen Din and K and Pham Hong T1. Part 4. Assessment of the Court. The procedure conducting agencies at the first instance stage has complied with its competence, order and procedures as prescribed in the Criminal Procedure Code. At the appellate court hearing, the High People's Procuracy in Hanoi withdrew all protests. The legal representative of the victim withdrew the appeal on the increase of the penalty for the accused, so the tribunal suspended the suspended trial with the above-mentioned protest and appeal according to the provisions of Articles 342 and 348 Criminal Procedure Code. At the appellate court hearing, the accused confessed their acts as stated in the first instance judgment. The accused confessions are consistent with the testimony of witnesses, assessment conclusions, and other documents and evidences that have been verified, enough ground to conclude. At about 1 o'clock on January 6, 2019, because he was jealous of Mr. Hong Kwok A Nguyen Ba Thi Nguyen Din and K to lead the way and invited Pham Quang V, Pham Hong T1 and other subjects to Hong Kwok A's house in Ward N, District L, Hanoi. Upon arrival, Nguyen Ba Thi directed T1 V and other subjects to use their hands, feet and wooden piece to repeatedly attack the victim, resulting in Mr. Hong Kwok A breaking the main bone of the nose, collecting fluid from the both sides of maxillary sinuses. Left hemisphere subdural hematoma, subarachnoid space hematoma, cerebral edema erased the boundaries of the brain coils in both hemispheres, right inclined midline. The brain system is out of balance. Hematoma under the scalp right apex. Swelling of the left temporal forehead, bruising and swelling of the forearms on both sides, swelling of the shoulder, back of the left hand, traumatic brain injury, currently vegetative, health damage rate is 100%. The case has accomplices. The accused behavior is particularly dangerous as Nguyen Ba Thi thought that the victim stole his lover, so he invited other subjects to Hong Kwake's house to take revenge and clearly stated the purpose of finding the victim to destroy it. Pham Quang V, Nguyen Din and K and Pham Hong T1 had no conflict with the victim but still agreed to follow the direction of Nguyen Ba Thi. The accused were aware of the dangerous nature and consequences of the crime where many people hit one person. Impact on key positions on the body, capable of causing the victim's death, but still did it. Acts of repeatedly attacking, using limbs, hitting or punching people in the face, hit the victim's head with a wooden piece until the victim lies motionless. Before leaving, he asked, "Did you kill him? Are you dead?" Clearly show the thug nature and subjective consciousness of the accused as jointly intentionally deprive the victim's life. Therefore, the first instance court's trial of Nguyen Ba Thi. Pham Quang v. Pham Hong T1, Nguyen Din on K for the crime of murder under point N, Clause 1, Article 123 of the Penal Code is grounded. The accused intentionally committed acts aimed at depriving the victim's life, but fatal consequence did not occur, which falls in the situation of incomplete commission of crime. Considering the appeal of Nguyen Ba Thi, the application of a life sentence to the accused is inappropriate, so it is necessary to amend the first instance judgment and reduce the penalty for Nguyen Ba Thi. Although Nguyen Ba Thi was the subject of confession, at the appellate trial he showed remorse, but given the nature and extent of the offense, the accused role and the consequences caused, it is necessary to apply the maximum penalty of the above provisions to rehabilitate and educate the accused and as a general deterrence and deterrent. Considering accused Pham Quang V's appeal, Pham Quang V is entitled to apply the new extenuating circumstances specified at point B, Clause 1 and Clause 1. 251 the Penal Code, therefore there are grounds to accept a part of the appeal, reducing the penalty of the accused. Considering the appeal of Nguyen Din and K, Nguyen Din and K is entitled to additional extenuating circumstances specified in point B, Clause 1 and Clause 2, Article 51 of the Code, entitled for lowest penalty under the clause penalty frame. Regarding Pham Hong T1, when he committed the crime, although Pham Hong T1 did not appeal, but in reference of the provisions of Articles 91, Article 101, Clause 3, Article 57 of the Penal Code, it is necessary to consider applying the maximum penalty that does not exceed 1/2 of the imprisonment level as prescribed by the law. The first instance level court decided 12 years in prison for the accused crime was beyond the scope prescribed for adolescent in Clause 2, Article 101 of the Penal Code, so it needs to be adjusted accordingly. On the other hand, Pham Hong T1 has the role of helping. After the first instance trial, the accused family additionally compensated the victim 35 million dong, so there is ground to adjust the first instance judgment, reduce the penalty for accused. Regarding civil liability, Ms. Pham Ton T2 did not appeal about the civil compensation content, so the decision of the first instance judgment on the part of civil liability was remained, but it is necessary to recognize the amount of money the accused have compensated. Regarding court costs, because the appeal was considered and accepted, the accused do not have to bear appellate criminal court costs. Part 5, Rules. To suspend the appellate settlement for the protest of the Chiad Procurator of Hanoi People's Procuracy and the appeal of the legal representative of the victim, accepting the accused appeal, adjusting the first instance judgment, reducing the punishment for Nguyen Ba Thi, Pham Quang V, Pham Hong T1, Nguyen Din and K. Applying point N Clause 1 Article 123, point S Clause 1 Article 51, points H Clause 1 Article 52, Article 15, Article 17, Clause 3 Article 57, Article 58 of the Penal Code, sentence accused Nguyen Ba Thi 20 years in prison for the crime of murder. The prison term is counted from July 14, 2019. Applying point N Clause 1 Article 123, point S, B, Clause 1, Clause 2, Article 51, Article 38, Article 15, Article 17, Clause 3 Article 57, Article 58 of the Penal Code. Sentence accused Pham Quang v. 19 years in prison for the crime of murder. Prison term from January 10, 2019, applying point N Clause 1 Article 123, points S, B, Clause 1, Clause 2, Article 51, Article 15, Article 17, Article 38, Article 54, Clause 3 Article 57, Article 58 of the Penal Code, sentence accused Nguyen and K to 10 years in prison for the crime of murder. The prison term is from January 8, 2019, applying point N Clause 1 Article 123, points S. B, Clause 1, Clause 2, Article 51, Article 15, Article 17, Article 38, Clause 3 Article 57, Article 58, Article 91, Article 101 of the Penal Code, sentence accused Pham Hong T 9 years in prison for the crime of murder, prison term from January 8, 2019. Note that the accused have compensated the victim in accordance with the decision of the first instance judgment. The specific amount, accused Pham Hong T 35 million VND, receipt number 004211 dated October 9, 2020 at the Civil Judgment Execution Department of Hanoi City, accused Nguyen and K 150 million, Dong, accused Pham Quang V 300 million VND. At the appellate court hearing, the accused and the legal representative of the victim confirmed that accused Nguyen and K and Pham Quang V had completed their civil liability according to the first instance judgment. The amount exceeded was voluntary by the accused family and no need to return. Content of the case law. The case has accomplices. The accused behavior is particularly dangerous as Nguyen Bat Thi thought that the victim stole his lover, so he invited other subjects to Hong Kwake's house to take revenge and clearly stated the purpose of finding the victim to destroy it. Pham Quang V, Nguyen and K and Pham Hong T1 had no conflict with the victim but still agreed to follow the direction of Nguyen Bat Thi. The accused were aware of the dangerous nature and consequences of the crime where many people hit one person. Impact on key positions on the body, capable of causing the victim's death, but still did it. Acts of repeatedly attacking, using limbs, hitting or punching people in the face, hit the victim's head with a wooden piece until the victim lies motionless. Before leaving, he asked, "Did you kill him? Are you dead?" Clearly show the thug nature and subjective consciousness of the accused as jointly intentionally deprive the victim's life. Therefore, the first instance court's trial of Nguyen Bat Thi, Pham Quang V, Pham Hong T1, Nguyen on K for the crime of murder under point N, Clause 1, Article 123 of the Penal Code is grounded. According to the conclusion of Forensic Examination of Injuries number 68/TTPY dated January 16, 2019 of the Forensic Center of the Department of Health H, Mr. Hong Kwak A has a traumatic brain injury, currently living in a vegetative state. The health damage rate is 100%. Thus, in this case, the accused intentionally committed acts aimed at depriving the victim's life, but fatal consequence did not occur, which falls in the situation of incomplete commission of crime.